I'm not as tall as Brent, so I got to move the mic down. Good afternoon. Thank you for joining us at the National Bar Association for this fantastic CLE. To the scores of people watching on Zoom, welcome. I'm going to do a brief introduction of Brent Hannafan, who left New York City in the law firm of Deckert in 2006 to join the U.S. Attorney's Office here in the Middle District of Tennessee, where he did a number of roles, and we'll hear about that over the course of this afternoon. The highest role he had there was the criminal chief for the Middle District. He left the office in June of 2023 and was asked several months later in mid-September, after joining a new firm, to work on the matter of Graham Chase Robinson versus Robert De Niro. And that's what we're all here about today. And with that, I'll turn it over to Brent.
Thank you. This bitch needs to get put in her fucking place. Those are the words of Tiffany Chen, the girlfriend of Robert De Niro. And the person Miss Chen was referring to as this bitch, who she wanted to put in her place, is the plaintiff, Chase Robinson. Those were the three opening lines of my opening in the trial of this case. So what I'd like to do today, and I understand some of you have seen the materials, there's a lot here. I'm going to talk about the trial itself, talk about openings, closings, direct, cross-examination, and professionalism. Any one of those could take an hour or more. So I'm going to try to get a lot in, and I will apologize for any rushing in advance. But these are the topics I'm going to go through. I was talking with my brother yesterday, coming in and said I was working on a PowerPoint, and he said how much he dislikes PowerPoints because people just get up and read what's on the PowerPoint. I'm going to try very hard not to do that today. So Graham Chase Robinson, she goes by Chase. She had worked for Mr. De Niro and his company, Canal Productions, for about 11 years when she resigned in April of 2019. You all know who Robert De Niro is, obviously a famous actor. He is also a very, very successful businessman. Those of you may not know, or some of you may know, of the restaurant called Nobu. And there are also Nobu hotels. There's something like 50 Nobu restaurants around the world. There's about 50 Nobu hotels around the world. He owns other hotels in New York, multiple restaurants in New York. Forbes estimated his wealth a couple of years ago at $500 million. He is a very, very busy man. Canal Productions is a company. It's just called a loan out company. And what that is they are the entity, the legal entity that people hire for Mr. De Niro's services, for his acting services, and the money flows through Canal. I'll talk in a minute about Chase's title. She, at the end of her time, was the Vice President of Production and Finance. And as defense counsel said during the trial, Canal Productions doesn't actually produce anything or finance anything. All they do is essentially take care of Mr. De Niro. And the people who work for Canal, their job is to do whatever Mr. De Niro would like them to do. Mr. De Niro and Chase. That's a picture of Mr. De Niro and his girlfriend, Tiffany Chen, who I just mentioned, and she plays prominently in this trial. So as background, what I was just talking about is Chase's position, her benefits. She got a lot of different benefits through Mr. De Niro working for the company. She had a number of different titles. At the end, within a couple of months before she resigned, she was making $300,000 a year. Right? That is a lot of money for what was essentially an assistant. She did a whole bunch of things for the company and for Mr. De Niro, but as you can imagine, the defense made a big deal out of the fact that she was making $300,000. Mr. De Niro and Ms. Chen began dating in around the summer or earlier of 2018. He had bought a townhouse an enormous townhouse in Manhattan, and they wanted to renovate it. He was moving in, and he ultimately put Miss Chen in charge of Chase and her responsibilities on the townhouse. Things between Miss Chen and Chase did not go well. She ends up resigning in April of 2019. When she did, she wanted a severance package, and she wanted letters of recommendation from Mr. De Niro. It was her view, her fervent view, that without a letter of recommendation from her boss of the past 11 years, how could she possibly get another job? There was a lot of back and forth. Ultimately, he didn't pay any severance. He refused to give her a letter of recommendation. She said she was going to look into having legal representation. And ultimately, that's what caused Canal to file a lawsuit against her in state court. In that lawsuit, they alleged damages of $6 million. No idea how they came up with that amount. I'll talk a little bit about the actual alleged damages. But when that lawsuit got filed, there was a firestorm of media attention. They alleged that she had stolen 5 million Sky Miles, Delta frequent flyer miles, that she binge watched Netflix, that she spent tens of thousands of dollars on Ubers and lunches and dinners at a restaurant in New York called Paula's, which she did, but they claimed all of this was improper. Chase ends up suing the defendants in federal court. Ultimately, what happened was the state court case got stayed and then later dismissed, and the parties proceeded in the Southern District of New York. The defendants countersued against Chase for all the claims they had made in state court. And when Chase filed her lawsuit, a voice message that Mr. De Niro had left her a number of years before was released to the media. I'd like to play that call. Yeah.
You're living in Spain and you're fucking upset with me because you tell me how nice you have it, your life over there, and you fucking don't answer my call. How dare you? You're about to be fired. You're fucking history. How dare you? With all the good things you do, this is bullshit. After Christmas, fuck this. How dare you fucking disrespect me? How much you did? You want a fucking another position? You want another position? Then say you want another position. Go off somewhere. But don't fucking get angry with me because I'm pissed off because I didn't get a simple thing that I need right now here out in California when I'm here for less than 24 hours. You gotta be fucking kidding me, you little brat. Fuck you. So quit whatever you want. God damn it. How could you fucking say you don't answer? You're upset because you're living in Spain. You spoiled fucking brat.
Yeah, that's a good call. So I would have loved to have started off my opening by saying, this is what it's like to work for Robert De Niro, and play that call. But the judge wouldn't let us. So leading up to this case, the judge granted summary judgment as against Chase on a number of her claims, some of, frankly, our better claims, we thought, and denied our cross motion for summary judgment as against the defendants. So the defendants had claims of conversion, breach of fiduciary duty, breach of duty of loyalty as an employee, and we had a gender discrimination and a retaliation claim. They alleged $6 million in damages. We initially alleged $12 million in damages. But the vast majority of our claims, truly our best claims, had been cut out. So this is our plan. Our plan was, number one, to defeat the counterclaims. I'll get into some more detail later. Ms. Robinson had not worked since April of 2019. We are now in October of 2023. The media portrayal was that she was this sort of, money hungry young woman. He calls her a spoiled brat. That's how she was portrayed in some of this. She left the company. She was gone for some time. And then there are all these accusations about what a terrible employee she was. in the media. If you were to search Chase Robinson prior to this trial, you would just come up with all of these horrible stories. And the damages for the Sky Miles and these Ubers, other expenses, was probably around $100,000. But if you're found to have breached your duty of loyalty to a company, the damages are that you have to return your salary for however long it was you were disloyal. So she'd been making about $200,000 in the few years or thereabouts in the few years leading up to termination, and a salary of $300,000 in the months before she resigned. She officially resigned. But she was looking at legitimately, if everything had gone well for the defendants, about $500,000 in terms of a verdict against her. So for us, number one was defeat their claims. Number two, obviously prove our own claims. And overall, our theme was, start strong, end strong. And we wanted to have a compare and contrast with the witnesses. And in particular, Ms. Chen, who was, I'll just say, a handful during her deposition, and compare her with Chase. So we were going to start strong, putting Robert De Niro on first as our first witness, get to cross him because he's an adverse party. Ms. Chen would be one of our last witnesses before Chase. And we were hoping that Chase would appear to the jury to be an intelligent, not appear to be, but would be perceived by them as the reasonable, intelligent, hardworking person that she was. And that's what we did. These are the witnesses very quickly. Mr. De Niro, Tom Harvey was an attorney for the company who did an investigation. Michael Kaplan was someone who worked at Canal, who did sort of odds and ends for the business. Michael Tash worked for an accounting firm that approved all of Chase's expenses. And that got into our defense of acquiescence and ratification. Sabrina Weeks Britton had been another assistant who had worked for Canal for a very short time, but was there when Chase left. Tiffany Chen, the girlfriend, Chase, her mother, who we decided to put on a little bit at the last minute, just for a few minutes to talk about the effects of what she had seen on her daughter after she left Canal. And we had an expert to talk about the emotional, psychological damages to Chase. The defendants only called Dan Harvey and their expert, Dr. Resnick. Dan Harvey is the brother of Tom Harvey, the attorney. Dan Harvey has been training Mr. De Niro since about the mid-70s. Works with him constantly. And he was somewhat relevant in that Chase had complained to Mr. De Niro that she should have been paid as much as Dan Harvey. And the defense wanted to make a big deal out of that, saying, well, he had very different jobs. Dan Harvey has worked with him since the 80s or the late 70s. And it kind of led to a nice moment for us during the trial. It was Judge Louis Lyman and his deputy clerk. Those are the attorneys for our side. Andrew McCurdy is former AUSA in New Jersey. Vince McKnight is the plaintiff's attorney, been his plaintiff's attorney his whole career. He had about 80 trials. Kate McMullen was a relatively young associate, but she had worked on this case since the very beginning for the 4 years prior to the trial. Andrew got on the trial, I want to say sometime around, or the trial team sometime around August. I got asked in mid-September. Vince came on at about the same time. Vince McKnight, I have to give him a shout out. He is a true pro, one of these calm, cool, collected trial attorneys. Nothing would faze him. So we decided Vince would do the cross of Tiffany Chen. We also had David Sanford, who's the named partner at my firm, Sanford Heiser Sharp, who's a very experienced trial attorney. He had been on the case, but got off of it when I was and asked me to get on it. He and Ali Harwin, another partner who'd been on the case for a long time, were there with us throughout the trial and sat in the front row every day. And I cannot tell you how wonderful it was to have their support and guidance each and every day, each and every minute of the trial, sitting right behind us. For the defendants, also Michael Lockman, someone who's here in our office. I have to mention Michael. He was someone behind the scenes doing research for us as issues came up. Laurent Drogan had been on the case for the entire time. Rich Schoenstein is a trial attorney who was brought on for the defense to try the case. He has a podcast called Showtime. very experienced trial attorney, wonderful guy, got along well with him, very savvy trial attorney who had tried a case and won in front of the same judge several months before. So I was a little leery of having, go into a courtroom. I'd never met the judge, had just gotten on the case, and I'm trying it against someone who'd won a case in front of the same judge a couple months before. And then Gregory Bennett and Brittany Lazaro, two other attorneys who'd been on the case. Brittany, kind of very similar, Kate, young attorney with no trial experience. So talking about professionalism, this is a fairly experienced group here, so I'm not going to harp on this too much, but I think it's important to show respect, not just for the judge, but opposing counsel, the witnesses, obviously the jurors. Not wasting their time is always a big issue. And finally, the clerks, the court staff. As my dad has said, it's not the judges who run the courthouse, it's the court staff. And we tried very hard to be respectful with all of them. So again, with an experienced group here, I think a lot of this will be very familiar, but number one is be honest. Kevin Sharp, we had some call. Kevin is a partner, one of the named partners of my firm, and we had a call talking about working on cases. And he had made a remark that when I used to appear in front of him as an assistant U.S. attorney, he knew he'd always get the straight dirt, good, bad, or ugly, and he could trust me. And so if I was pushing for something, he knew he could take my word. And I would also tell him if something had gone wrong, if we had made a mistake. I think it's very important, if you don't know something or you do make a mistake, to own up to it, which I had to do a couple of times in trial, and hopefully I'll get a chuckle out of it later. So the pretrial conference, we show up. Kate had been on the case for a long time. Andrew, Vince, and I were all new to the case, and we're sitting there, and the way the tables are set up, it's front and back. In the Southern District of New York, in this courtroom, they're front and back. So plaintiffs are in the front, defense are in the back. I mean, you could barely back your chair out. It is a tight well, so to speak. But the deputy clerk comes out and says, okay, for plaintiff, who's lead counsel? And Andrew looks at me and goes, you got this, right? I was like, sure, okay, I'm lead counsel. So I became lead counsel that day, which is a surprise to me. Trial was scheduled to start on a Monday. The following Friday was a federal holiday. The court made it very clear to us we were going to be done with trial by that time. He gave both sides 20 hours, and the deputy clerk kept the clock. So and that included openings and closings. So half an hour for opening, hour for closings. We had 18 and a half hours to present our case. So if we were presenting a witness, we were on the clock. If they did the cross or the direct of the adverse witnesses, they were on the clock. There were timeouts for sidebars and breaks, obviously, and all that. But ultimately, as we were getting into the second week of trial, we were literally checking our watches to see how much time we wanted to have left with a particular witness. Motions in limine. So there were two big things that came out of it. One was an issue with Sky Miles. They had alleged that Chase had stolen 5 million Sky Miles. That sounds like a lot of Sky Miles. It was. They were generated through Canal's corporate American Express card. So the company was racking up, hundreds of thousands of dollars of bills every month, and they'd pay it off. And these Sky Miles built up on the corporate card. And as you hear, Mr. De Niro, at some point, had agreed that Chase could get those miles so she could travel. It was like a perk, a benefit of her job. But one of the big issues is they weren't able, during discovery, to put a value on the Sky Miles. Now, you can go on a website and figure out it's about 2 cents a mile, sort of on average. But during discovery, the defendants had come up with varying valuations, and not based upon anything that someone at Delta said. This was kind of a back of the envelope. So we were pushing very hard that they could not call someone to testify about the value of the Sky Miles. they had noticed a representative instead of subpoena for representative of Delta to come testify about the value of Sky Miles. Never been deposed, no affidavit, would just get up and testify. We objected, said that'd be like calling an expert to come give testimony. We'd have no way to rebut it, trial by ambush, those sorts of things. Thankfully, the judge agreed with us on the grounds that they hadn't disclosed it in discovery. The other big issue we were pushing with was we wanted to play that call. I wanted to play that call so badly, right? Because I figured if the jury could hear what Mr. De Niro was really like, what it was really like to work for him, they would understand all these things that I expected Chase to testify about how difficult it was to work for him. Now, that recording was from 2012, and he's making some reference to Spain. He agreed that Chase could work from Spain or England or LA at different times, and she did. And what he was upset about is she had, at least he believed, she had failed to call him and wake him up while he was in LA on a trip one morning, and he missed an appointment. She had a different explanation for it, but that's what set him off. And the judge said, nope, doesn't have to do with this case. It's way too early. Nothing about, nothing basically wrong with having someone be, a jerk as a boss. Having a bad boss is not illegal. It's not coming in. Multiple other times during the trial, things came up where we tried to get him to change his mind, but it never got played. So in terms of building rapport, knowing that the call was out, I knew that I wanted to start with, this bitch needs to get put in her fucking place. That was a quote in an email by Tiffany Chen, and it was in reaction to Chase sending an email to Mr. De Niro. I'd known, weeks in advance, I wanted that to be my opening line if I couldn't get in the call. So I said to the judge, I said, we're going through a number of things about trial. I said, Your Honor, I said, I just want to talk about some language here during the trial, and the court had read the summary judgment briefs. I understand there's a lot of salty language. I said, there's a judge, federal judge in Nashville, who does not like attorneys to use that type of language during trial. And I said, so I just wanted to know if we'd be permitted to say those sorts of things. And I did that, number one, because I knew I wanted to use this line. And it's a direct quote. I thought, of course, I should be able to use it. Number two is also a tip of the hat of like, I'm showing my respect to you. I don't want to do anything in front of Your Honor that might upset Your Honor. And he essentially said, well, that is what was said. Got me in front of a bunch of New Yorkers for a jury. Sure, it won't be the first time they've heard this language. And I just ask you don't abuse the privilege. And I said, yes, I get to use that line. So if you haven't been to the Southern District of New York, you cannot take your phone. Anyone cannot take a phone or computer in unless you've got an order from the court. Only members of the trial team are allowed to do that. And we would literally have to show the order each morning as we're coming into the court staff. Very, very tight quarters. The lectern was not even this big. Juror number 4 was sitting literally here. I could have reached out and touched her. The witness stand to the front of the table is probably from where Luann is sitting there. Very, very tight quarters. Large gallery, but in terms of the well and where you are to the jury, very tight. Jurors could have whatever they wanted in the jury box. They'd bring in their coffee or their tea. Court would serve them breakfast in the morning, which was very different from my experience here in Nashville. With the large gallery and obviously with the movie star being on trial, it would be crowded. At times, it was literally standing room only. The press would be there. And I thought it was kind of funny with pen and paper or pencil and paper because they were not allowed to have their computers or cell phones. So big picture themes, start strong. You always want to start strong. You always want to finish strong. Really enjoy Michael Jordan dunking over New York Knick.
Seems unnecessary, bro.
Yes, right. And this applies across the entire trial. Your openings, your directs, your closings, your cross, however you're going to do it, you want to start strong and end strong. Do you address bad facts? Of course you do. some very experienced trial attorneys in this room. You have to get out the bad facts. And if you're, rather than wait for opposing counsel to do it, you want to do it. And where do you do it? Try and do it somewhere in the middle, right? Start strong, end strong, bad stuff in the middle. A friend of mine, Rob McGuire, likes to say, you got to take the trash out at some point. So take it out, do it in the middle. Hopefully they're distracted by the strong start and finish. I also think it gains credibility with the jury. If you admit and you put out your version of the bad facts, when the other side tries to bring it up, hopefully they will have said, I've already heard this. It's not as big a deal. I'm a very big believer in varying tone, your pace, your volume. Had a wiretap case a number of years ago. And in talking to the jury in opening statement, I said, there's a wiretap in this case. And ladies and gentlemen, you're going to get to listen to the calls. You're going to get to hear what they were saying when they thought no one was listening. And you could literally see the jury leaning forward, right? It's kind of voyeuristic, but slowing down, going lower in volume, all of these things I think are effective. Obviously, to engage the jury, looking them in the eye, looking the witness in the eye. Right? If you want to have people talk about having control of a witness, particularly on cross, if you are looking down at your notes, you're looking at your not question, you're not listening, you are not going to have control of that witness. Signposts and pauses. Big fan of the signposts. I know a lot of these are very common themes you all have probably heard before, but saying, here's what we're going to talk about next, or let's turn to this, or I'd like to talk about now the deal let's talk about Sky Miles, right? It orients the witness, orients the court, orients the jury, and then have a pause. Let everybody catch up as to where you're going next. And finally, letting the good lines hang in the air. You get a great answer. Just let it hang, particularly with the jury. We got a couple of them in this trial, and it was nice to let them hang, particularly in a courtroom. The mirroring, I'm sure many of you are familiar with this. It's essentially you mirror how the witness is. You've got, an aggressive, blustery witness. It's okay to give it back to him a bit. You've got someone who's meek and who is quiet, third party who really doesn't want to be there. You're not going to be nearly as aggressive. You're not going to have the same tone as you would with a different witness. Check and double check your technology, right? Before I got here early, wanted to make sure we could play the call. And thanks to Cameron for doing that. Wanted to make sure this is working. The absolute worst thing you want to do is to stand up for your opening statement. You got your PowerPoint, a couple slides ready to go, and it doesn't work. Or you hit play on that first call and it's so loud it blasts everybody, and then you've got to fix it. Check your technology and do it right before you start. All right, objecting. I hate objecting. I don't like doing it. I don't think the jury likes it because I think, what are you trying to hide? I think the judges like it because it makes the trial go longer. They've got to respond to all the objections. There are times you have to do it. But my recommendation is the less you can do it, the better. In this trial, unfortunately, I objected more in this trial on the cross-examination of Chase Robinson than I did my entire career of trials at the U.S. Attorney's Office. I didn't like doing it. I felt we had to. Frankly, there was some pressure to be doing more of it than I would have liked. But it was good advice and looking at the record. But I think what ultimately happens is the jurors say to themselves, like, why are they doing this? What don't they want us to hear? And if the judge keeps sustaining the other side's objections or denying yours, you just look like you're trying to slow things down. So one thing I would recommend, particularly for the newer attorneys, if you get an objection during an examination, sometimes attorneys will just say objection. The judge will say sustained. ask what the objection is. Was it leading? Was it some other issue with the form? Was it compound? Whatever it is, ask what it is. And I had to do that in this trial because the judge and defense counsel kind of got in a rhythm. Would be objection sustained, objection sustained. I was like, I'm sorry, what is the objection? I don't even know what the objection is. If I know what it is, I could try and fix my question or go a different route. But that's key. If you're getting a lot of objections, ask what they are. All right, opening statements. Before we get to that, very quickly, this is different from how I'd seen it done here in Nashville. Judge Lyman gave out a questionnaire of 45 questions to about 40 some jurors. And what they were to do is just mark all the questions were either yes or no. And if you're answering yes, it meant there might be something to talk about. Like, do you know any of the parties? Yes or no. Have you ever worked for Canal Productions? Yes or no. And the judge went through it, all the questions with juror number 1, and then went to 2, 3, 4. And by the time he got to, 2, 3, 4, he would just say, do you have any yeses? And he would address those. It was extremely efficient. Juror number 2 was a little bit of an older lady, and she had answered a question about having strong feelings about one of the parties. And the judge said, can you tell us what that is? And she said, well, I'd rather approach. So we all go up and we approach. And the judge says, we all crowd around, and the judge says, can you tell me, what it is you have strong feelings about one of the parties? And she said, I don't like Mr. De Niro. I think he's very arrogant. I read about him. I don't like him at all. And the judge says, okay, thank you. And she walks away, and he turns to us and he goes, well, I'm gonna strike that juror. Plaintiff, what's your position? I said, Your Honor, she sounds like the perfect juror. We all had the chuckle. I said, no objection, Your Honor. And I'm sure all of you who've tried many cases have had those moments, but it was worth a laugh. So this is the template that I use for openings. A couple of questions in there are, do you discuss counts and elements? Depends upon the case. What do you expect the trial is going to look like? Do you discuss the burden of proof? Maybe. Again, it depends upon which side you're on and what the type of case. But importantly, tell the story in broad strokes. Do not get mired down in the details. I love opening statements. When I first got on this case, I said, my colleague and now friend, Andrew McCurdy, had been prepping for the cross of De Niro. And I said, you can do the cross of De Niro, but I want the opening statement. That was the deal we made. I didn't know I was also going to do the directive chase, which was a bit more laborious. They're wonderful, but I love doing openings. I really think it sets the tone for the case. It gives the jury your view of it, and hopefully is a prism through which they'll look at the rest of the case. So how do you give an ineffective opening or closing? Anyone?
Roadmap.
Close. I'm going to get to that.
Read it.
Read it. Thank you. Easy. That was a layup. Come on. All right. Read it. Right. If you're sitting there looking down, reading it, we've all been in the audience. You have no eye contact. People don't pay attention. I've taught it at Belmont Law School trial ad for a number of years. And the students are always super nervous about trying to give their opening or a closing without using notes. By the end of the semester, all of them can do it. Anyone in this room can do it or has done it. So for those of you inexperienced attorneys out there, you can do it. If I can do it, you can certainly do it. It just takes a lot of practice. You got to do it again and again and again. Recording yourself, I hadn't done this until this trial, but we had like a jury consultant team who was working with us. And I gave a moot a couple days before trial and got to watch myself on video. It was a little painful to watch. I think we all think we probably present better than we do, but I had a couple of tics. I play with my ring, which I noticed, and I kept pursing my lips. That was because I hadn't memorized it yet. It was still too early, but I said, man, I really need to get this thing memorized. Shorter the trial, the shorter the opening. When you do a moot, when you practice it, if you're going to use exhibits, do it with the exhibits. If you're on the clock, get timed, right? It doesn't do you any good to get it up in practice when it's not exactly the way it's going to be when you're at trial. If you can do it with non-lawyers, yes.
I'm just gonna say.
Sure.
Quick rules, as it pertains to the relationship between opening and overall trial and 1 day trial, how many minutes of an opening?
1 day trial, maybe could literally be 5 minutes. This was a 2-week trial. We were given half an hour. I think that was about right. You know, what you don't want to do. I mean, you're not going to get up and talk for an hour when the actual proof sort of all told may take 3 or 4, maybe 6 hours. You just get up and be succinct. This is what this case is about. This is what I expect you'll hear. This is the relief I would like to seek. This is also a point about viewing it in the context of the entire trial. So when you get up to give your opening, they've been through voir dire, the jury has been through preliminary instructions, then you're giving your opening. Okay, so there is no need to go into sort of the background. I don't know about others of you who've tried cases, but like this is what I see when I stand up to give an opening statement, right? It's just these faces. They're like, I can't believe I'm here. Maybe they're interested it's Robert De Niro, or they've heard this, you know, some exciting criminal case, but they don't want to be there. Right. So you got to start strong. You got to have your hook. Do not introduce yourself. Do not introduce the other members of the team. Do not talk about how it's like a roadmap, right? You're wasting time. Do not talk about how it's like coming attractions. Okay. Now, I have given a talk on openings and used this exact slide well before I ever went up to New York for the trial. I gave a moot opening to members of my firm in a conference room and on Zoom the Thursday before trial. And I got up and I started like this. Good morning, ladies and gentlemen. My name is Brent Hannafan. I work at the law firm of Sanford Heisler Sharp. With me is Vince McKnight. Vince, would you stand, please? Andrew McCurdy, Kate McMullen. We've got Jamie Kelly. He's our tech person here. And this is Chase Robinson. It's very nice to meet all of you. So, ladies and gentlemen, an opening statement is kind of like a roadmap, and I'm gonna show you how it goes. But some of you are probably movie fans. It's also kind of like coming attractions. This is gonna be a preview, and then you're going to see the whole movie. And I stopped because I was joking, right? And I'd done this once at the U.S. Attorney's Office, and it got a bigger laugh than all my colleagues at my new firm, who didn't know me, and very few had actually tried cases. So I said, I'm just kidding. I think there's a collective sigh of relief. And then I started with, this bitch needs to get put in her fucking place. Preparing yourself. Again, for those of you who are more inexperienced, your adrenaline will be going. You tend to speak faster. Your mind races a bit. Sit down and take a bunch of deep breaths. I do this every trial. Closing, opening, I would literally be sitting at a counsel table, taking long, slow breaths. Try to calm the nerves. I'm not so much nervous as I am excited, but that adrenaline is going. And when you get up to talk, if it sounds like you're going too slow in your head, that is the right pace. You've heard my first 3 lines of my opening. These are the first 3 lines of the defense opening. Starts talking about a movie, like coming attractions, plot twists, the villain, popcorn. After that was over, all of us kind of chuckled about it. They're like, he did the joke you did. He did the coming attractions joke that you were just joking. He did in real life. I would have done something like this. Right? The plaintiff is a liar and a thief. She lied about how much she was working. She stole money. She stole sky miles. That, I think, would have been a more effective defense opening. Tell the story through the cocktail version of it. You know, you're just talking about how long would you go? I would give the cocktail version of what you expect the trial to be. Do not overwhelm with details. This is a much longer story, but I'll make it quick. My first trial at the U.S. Attorney's Office, it was a wiretap case, a lot of cooperators, all of whom I had met, all of whom I knew their names, all Hispanic last names. And as I gave a moot opening for my mom and dad, who had proudly come to see me at my first trial, I was going through all these names, and I could tell I'd lost my dad halfway through. And I got done. I said, "So what do you think?" My dad said, "You lost me with all the names." Right. So I figured if he, who'd heard me talking about the case, got lost with them, I couldn't use all the names. So I said, well, would it be better if I said, you know, the boss, the right-hand man, the courier? Yes. So don't get bogged down in the details. Try to paint it in broader strokes that people can understand. I like to say in my closing, essentially, I told you so. So I want to tie my opening to my closing. I also like to try to plant a seed, something I expect will come up at trial that I can specifically point to in closing and say, remember when I told you about this? And I did that in this case. I talked about how they were going to hear from Mr. De Niro and they were going to hear from Chase, and they were going to get to compare their memories. Mr. De Niro in his deposition had a lot of I don't knows, I don't remember. As I said, this is a very busy man. These things had happened years ago. Frankly, I wouldn't expect a lot of us to remember some of these details, but I knew Chase remembered them, and she had emails and documents and texts we'd be able to go through. So I set that up, that you're going to get to decide who you find more credible. Do you discuss counts, elements, the law? Probably not an opening. The law, it's risky. Jury instructions may change. You don't know what's coming. I would avoid any discussion of that. Do you address the other side? Now, again, this is the perspective of a former prosecutor and now plaintiff's attorney. I wouldn't want to talk about the defense's case or what they're going to say, because they could say something entirely different. Burden of proof, probably wouldn't talk about it. Have maybe a line what the standard is, and that's it. If you're a defense attorney in a criminal case, I would harp on it more because it's a high one for the prosecution. The evidence will show. I think if you say it once, if at all. I never said it in this opening. I'm not sure I've said in any of my openings. Just get up and tell the story. If you get an objection, you can say, the court sustains it. Ladies and gentlemen, this is what I expect the evidence will show, and then go on with your story. Do not need to thank the jury for being there. They've been subpoenaed. They have to be there. And if there's something you think might not get in, don't even touch it. Get your motions in limine in early. Push to have the court rule on them before openings. If the court hasn't ruled, at least raise it with the court, that neither side will bring something up that hasn't been ruled on as of yet. Have the last few lines at least memorized. Tell the jury what you want at the end of your opening. Again, this is my practice, but I think it's effective. So this is how I ended it. Wanted the line of De Niro, putting De Niro and Canal in their place, just like Tiffany Chen said she wanted to put Miss Robinson in her place. And I, of course, couldn't help but use the word justice. This was the end of defense counsel's opening. He ran over time. I was sort of sitting there thinking to myself, this is going longer than what seems like 30 minutes. I didn't want to look at my watch. The judge cut him off, and that's how he had to finish. I don't think that is a strong finish. Sort of a lesson learned for this. As a prosecutor, you get to wrap yourself in the flag, the American flag, flag of the state of Tennessee, and you've got sort of that trust, I think, inherently with the jury. As a plaintiff's counsel, you do not. You are someone who's there asking them to give money to you and your client. So I think, again, it's important to work on the rapport with the court, work on the rapport with the jury to come off as trustworthy as possible. And that means keeping your word. What that means is what you say in the opening, expect to be in the trial. And then in your closing, you can come back and say, I told you so. All right. I'd like to talk about cross-examination now. Normally would talk about direct, but in this case in particular, we called adverse witnesses. Mr. De Niro was our first witness. So I'm going to talk about cross-examination and some of the things that came out in the cross in this case. If there's bias, put it right up front, right? Put the witness a little bit on their heels, let the jury know why this witness might be more interested in the case than someone else. Leading questions. I'm sure all of you have heard this, right? Short, very short statements, if you can. You don't always have to say right or correct, or isn't that so? If you say it over and over and over again, it gets kind of annoying. I think it's annoying when I have to listen to it and someone else is doing a cross. So I take it it's annoying for the jury as well. Only know the, questions you only know the answer to, unless you feel pretty confident of what the answer is going to be. And we had a couple of those in this case. Do not rehash direct. I've seen many criminal cases, defense attorneys get up and they start asking the officer or the agent or the cooperator about what it was they just talked about. That is not helpful to the defense. It's helpful to the prosecution. They get to talk about it all over again. Don't rehash the direct. Get your points, be specific, focused in on something, try to get some bricks that you can use in your closing. These were two of the witnesses that we called, Tash and Harvey. Right up front, we got out the bias that they had. Michael Kaplan, Sabrina Weeks-Britton, all of them were still working in one form or another for De Niro. That came out immediately. So this is an example of bias with Mr. Kaplan, where Andrew McCurdy was asking about, says, you want to keep working for Canal? And he says, no, I'm a real estate agent. I have a podcast. Writers get so much. He says, oh, don't you appreciate receiving money? No, I'd like to get paid, but not so much. You wouldn't turn down working for Canal. I got a real estate license. I got a podcast. This isn't a resignation letter or anything, right? Like, what should he have done? Is kind of the point of this. What should Michael Kaplan have been prepared to do when he got asked, aren't you still working for Canal? Yeah. Yes, I'm working for Canal. Part-time, but yes, I'm working for him. Okay, turn the page. He didn't do it. I have to say, in the closing, so I gave the opening, I did the direct and redirect and chase, and I did the closing. And in closing, I couldn't help but get a little snide about his comment. I said, wow, I didn't check anymore. I said, I haven't listened to it yet, but I'm sure it's riveting. And I got a chuckle from the jury. All right. The pitfalls, asking a question without knowing the answer. This is a bit long, but essentially what happened was Chase was getting cross-examined, and there'd been some talk about her. She would keep all these hard copy records, and then she would shred them and she'd organize them. And they were trying to portray it like, well, that's what she was just doing all the time. And so he goes into this about, didn't you do this? So you spent a lot of time in your work scanning documents and then shredding them. That was a big part of your work? It was no. And she gave this reasonable explanation as to what she'd been doing. Not a huge oops, but it does illustrate the point of don't ask a question if you don't know the answer on cross-examination. So I'd mentioned with Chase and Dan Harvey had been this trainer, Mr. De Niro's, for many, many years. And he was well paid, frankly, as he should be. He dedicated, hundreds, thousands of hours a year for Mr. De Niro, traveled all around the world. Mr. De Niro goes on set, Mr. Harvey goes with him. They've been very, very close for many years. And the defense wanted to make a big deal out of the fact that Chase had complained about not getting paid as much as Dan Harvey. And so right up early in the cross, defense counsel was questioning her about, well, what were you doing in 1983, which is around the time Dan Harvey started working for Mr. De Niro. And at the time, I think Chase was 2. And then he says, what were you doing in 1993 when he started working full time with Mr. De Niro? She says, recovering from a brain tumor. Recovering from a brain tumor at age 10 or 11. We knew about this. And there'd been some pressure to get that out on direct. And I said, I'm not doing it. I think it'll look like pandering. It's not relevant. And by pandering, I mean, the jury's going to think I'm trying to get some sympathy for her. She's a 40-some-year-old woman now at this time. She's had some side effects from that to this day, which I won't get into, but I wasn't going to bring it out. And then he steps in it. Now, the worst part was his response. I'm sorry about the medical issues, comma, but do you think you should have been paid as much as somebody working? He didn't say, I'm sorry, I didn't know. He didn't say, my apologies, I didn't mean to do that. I mean, we couldn't, sitting at counsel's table, we couldn't believe it. Not so much just the bomb going off of the brain tumor, but how he reacted. And again, I'm not here to malign Rich. He's a very, very good trial attorney. But I think he would have been better served had he just taken a beat and said, I'm sorry, Ms. Robinson. I didn't mean to ask you about that. I'm sorry you've undergone that. And can we return to the questioning? Right? It did not play well with the jury. So this is part of the cross to Mr. De Niro. One of their allegations was that Chase had lied about vacation days, that she hadn't taken vacation days. She would be in Spain or London, wherever. And at the end of the year, she would say, I didn't take any vacation days, even though she'd been traveling. And part of that was because she was on call 24/7. Mr. De Niro called, he wanted her to pick up the phone, regardless of where she was, as you heard from that call when she was in Spain. And we figured, rightly, that he would not be able to say any specific days that she hadn't worked. So this was the cross, when was it? I don't remember. How about this year? I don't know. How about this year? I don't know, right? The person who was suing her, couldn't say when it was that she'd lied about vacation. And this is someone who knew where she was every minute of the day and approved her getting paid for unused vacation. So this was a bit of a roll of the dice in asking a question we didn't know the answer to, but we felt pretty confident he wouldn't be able to answer it, and he couldn't. So as part of what happened is there had been a fire at the townhouse, and Mr. De Niro and Ms. Chen had a couple of little dogs. And Chase had been in charge of setting up the fire alarm, the ADT. So when this alarm went off, it was her number that got the call. So she tries to call Mr. De Niro. He wasn't around, calls Ms. Chen, and then she rushes over there. Ms. Chen had left something on the stove and there was smoke everywhere and had set it off. But Chase goes in and the first thing she does is takes care of their 2 little dogs and puts the dogs outside. And then she goes to try and stop the fire. And what we wanted to do was to get out this fact of that, here's Chase, loyal employee, loyal servant to Mr. De Niro, and she's got a good heart. And this is how we wanted to end up finishing it. Got that point out. Hopefully some folks on the jury said to themselves, you know what, Chase Robinson isn't nearly as bad as these people are trying to make her out to be. Various types of impeachment. Again, looking at the room, very experienced attorneys, these are a variety of ways that you can impeach people. Obviously, the gold standard is a prior inconsistent statement, a deposition, an affidavit, prior testimony, etc. Having gone, now being back in civil practice, it is very, very important when you're taking a deposition to get a clean answer, right? Not a maybe, word salad answer. If you don't get a clean answer, ask the question again. It is very hard to impeach someone at trial if you don't have clear question and clean answer. I think something else that is very important, the more I'm seeing it now, is what preparations did the witness do for the dep? How much time did you spend? What documents did you look at? How much time did you spend with your attorney? How much time did you spend looking at documents? Because if they can't answer a question at the time of the dep, it'd be very hard, whether it's a year or 2 years or 4 years later, to get up on the witness stand and say, oh, suddenly you remember all these new things. So I think that is important to do during your dep. Impeachment mechanics, if it's an adverse witness, you want to impeach them. If it's a friendly witness, you want to try and refresh their recollection, right? And I won't get all into the details, but essentially, Mr. McGuire, do you recall what day it was you met your wife? No, I don't remember. Is there anything that might refresh your recollection? Yes. Show that to the person, they can look at it, they don't read it aloud, and then they're able to answer the question. Get someone to commit. Say, you said this before, earlier today, you testified to X. Yes, isn't it true? When you gave your deposition, you said something different. It's not so much a question as it is a statement. You said something different previously, correct? If you get a point, I could talk about before, pause. Be careful about the summary question. You take a number of pieces of testimony, you wrap it all together and say, isn't it true, Mr. McGuire, you met your wife on this day and you're at this place and you said this and such and such. They tend to get very long, particularly if it's an adverse witness. The adverse witness won't just say yes. They will quibble. Keep them short and sweet if you can. Also asking the witness, not just what they did, but what they didn't do. Well, you didn't ask about this. You never told Mrs. Robinson she couldn't take vacation time. No one ever told Ms. Robinson she couldn't charge that on the Ubers. No one ever told her she couldn't charge these meals. No one ever went to her after they got her credit card statement and said, what is this? Right? Get all those negatives out. So on the Sky Miles impeachment, we were trying to make the point that Canal, the company, never actually paid any money to get these Sky Miles. These are all just being generated through their purchases of other things. Fairly straightforward question. Mr. De Niro says, I don't know. Well, he had testified, in fact, that they did not have to. So Andrew said, I'd like to impeach. And the way we would do it in front of Judge Lyman, you say, Your Honor, I'd like to impeach. We'd tell him the portion of the deposition, the judge would look at it, decide whether in fact that could be a basis to impeach, and he would say okay, or the other side would object or not object, and then impeach. So that was a clean question. At any point in the last decade, have you or Canal purchased Sky Miles? I don't think we had to. And then Andrew ends it with, that was your testimony. That was your testimony, sir. He's not arguing with him. Just, that's what you said, period, and move on. So I have a colleague who's an AUSA in Virginia, Stephen Miller. I have to give him credit. He talks about not crushing your bricks. Get a brick, get the answer we just had here, right? They never had to actually purchase those. That's the brick. Right? Don't go into, well, so it didn't cost you any money, or it didn't matter that Chase used these. There was no harm to Canal. That's going to be an argument. De Niro would not have agreed with all of that. So get your brick and then just use it in your closing. I think it's a terrible idea if things aren't going well on cross to ask the judge to instruct the witness to answer. I think you are much better off asking or re-asking, say, excuse me, ma'am, I'm sorry. My question was this. And if they won't ask it, maybe you go a third time. But me saying, hey, judge, I'm having problem with the witness. I can't handle this myself. Will you please tell this witness the answer? Right? You don't look like you're in control. You know, you're asking mom or dad for help. Instead, just save it. And then when you get up in closing and say, remember I was questioning Miss Booth? She couldn't even answer a simple question. I asked that question 3 times. She wouldn't answer. Why? Because whatever you want to argue. All right. I've kind of given this one away. After you impeach an adverse witness, what do? Stop. Right? Move on. Get your answer. Move on. Do not argue. All right. This is a very long answer. But one of the issues that came over the Sky Miles is Mr. De Niro had claimed, well, he wanted these Sky Miles for his kids. He has a number of kids, a number of grandkids. And he gave this really long answer about how, just in short, they didn't use Sky Miles to book flights for him or his family. He didn't fly on Delta. I think he flew on Delta 1 time, as far as Chase knew, in 11 years. He was flying on private jets. But he wouldn't answer it. So again, there's an impeachment. And even with the question at the end, that was your testimony, right, sir? De Niro starts to go on. That was my testimony. That's what I was saying, etc. Andrew says, move to strike the unresponsive, and it's granted. Great job by my trial partner. All right. So this is, I think after a number of impeachments, a witness can get a little gun shy, and they think that whatever you're asking them, you've got in a dep, or you've got in a document, you've got in a text somewhere. You can tell Mr. De Niro was getting a little gun shy. He asked a question. He says, if you can remind me with the deposition, fine, I'll look at it. Right? He figures Andrew's already got the answer. It took place. This is a critical conversation. Here's where it took. Well, what do you tell me? All right. Can you show me something? And ultimately at the end, he asked them whether Mr. De Niro and Chase had agreed that she could get Sky Miles because he didn't give her a raise. And that's what Chase remembered. And that's what she was going to testify to. And he says, no, but it could have happened. That was huge. It could have happened. That was all we really needed. This is kind of one of the more highly reported portions of his testimony. Chase had said she was always on call. And there was a time when she was going to her grandmother's funeral, and she said, I'm going to my grandmother's funeral. I'm not going to be available today. And he called her twice. And I was planning to have her testify about that as an example of how she was always working for Mr. De Niro. And when he gets asked about it, he called her twice. If I did, and I did. And he says, oh, you can pull up whatever deposition. And then he says, even if I did, it's a whatever. Awake, I don't know. It's not like a funeral where they're putting the body in the ground or something. I don't know what all this nonsense is, but fine. Hey, as long as they're not putting a body in the ground, who cares if I'm calling her? Did not play well with the jury. Again, I mentioned this a bit, particularly on cross. You want the mirroring. If you've got a tough witness, it's okay to come after him a bit more. A family member, disinterested third party, I'd take a lighter touch. We've been going about an hour. Josh, if we want to take a 5-minute break, people like a break? Yes. Okay. Quick 5-minute break. Sorry? Okay. We've met at Toby's house.
Hi, good to see you.
You know what? I mentioned
I know.
on my site.
I also
I didn't
noticed,
know everybody was getting all of it. But.
I noticed that
That's fine. I figured it's fine.
the part you skipped over was my cross.
Yeah.
Right. I was like, he saw me here and he skipped over the, what not to do in cross. That was so good. It's so good.
Well, did that happen to you last week?
It's like, it's how you get it. Well, that's work.
All right, thanks.
Yeah.
See you later.
Yeah.
All right, y'all ready to get back to it? All right, so Tiffany Chen. Tiffany Chen's cross-examination will be very important. She was a key player in this story. She got jealous of Chase, her relationship with Mr. De Niro. She said a lot of not so nice things about Chase. And ultimately, she was the one who told other people they were not to communicate with Chase about any work on either Tiffany Chen's or Mr. De Niro's projects. That was the retaliation. So this is what we wanted to do. Get out these bricks and obviously contrast Ms. Chen to Chase. So under the law that was applicable, the New York City human rights law, gender discrimination can be committed by a man against a woman or a woman against a woman. And this one was huge. And these slides were from my closing. When you see like this type of slide, that's the closing slide that I actually used. If Mr. De Niro discriminated against Chase out of a desire to appease a romantic partner's jealousy, that is actionable. All right. This is a very liberal law. But this is something we want to get the evidence out to hang our hat on this in closing. So this is some of the language from Ms. Chen's texts or emails. Yes. Yes, these are all closing slides. And I'll note something I like to do, I think is important, is you have your exhibit number when you're going through. There's always going to be some note takers. So when I talk about a particular document or exhibit, whatever it may be, I will give, this is for plaintiff's exhibits 4, et cetera. So the jury could go back and could look these up. Who here knows what she's talking about? It's very single white female. The movie, yes. Defense counsel had a big thing about like, it doesn't mean the movie, who knows what she meant. And then she got up on testimony and testified. She's like, yeah, I was talking about the movie. And then I got in trouble in closing, which in New York they call summation, because I said the movie was about a young woman who moves in. It's a young woman who has a roommate move in who is a psychopath and tries to take over her life. And I got chastised because the fact that the storyline of the movie did not come on evidence. So I wasn't supposed to talk about it, which I didn't know at the time. But yes, this was a key one. And this is the real issue. It's like you can't make decisions with me, but you can't make them without her. This was Tiffany talking to Robert De Niro. This is what she was really jealous of. She didn't like the fact that De Niro was relying upon Chase as opposed to Tiffany. So Michael Kaplan gave us a nice line, and he had said this in an email. I can't remember if it was an email or text that we got in discovery, that Ms. Chen wasn't a reliable narrator when it came to pretty much anybody. Vince McKnight went through a series of texts or emails that Ms. Chen had sent, where she was saying how nice Chase was, how wonderful Chase was. And she got asked about that in her deposition, and she said, well, no, I was trying to kill her with kindness. When I said angel, what I really meant was a-hole. Things like that. So Vince crossed her, and he went with these statements, and it was fantastic. True or false? Her answer's sarcastic, but true. Sarcastically true. Very sarcastically true. Can't see it on this last line, but very, very sarcastic, but true in my sarcasm. Okay. This is what I said in closing, as I went through that exact slide, and I said to the jury, do y'all remember this? Like, if y'all know what this is, then you're all smarter than me. And they laughed. They laughed because it was so ridiculous as to this position that she was taking. Save the hard questions for the end. So with Mr. De Niro, he is, I think now 80 years old. He didn't want to be there. He was on briefly on Monday afternoon, and then he was on for several hours on Tuesday morning. I think our cross continued until after lunch. He was tired. He was cranky. He didn't want to be there to begin with, and he just got kind of worn down. But I think with any witness, if they're on for several hours, if you're going to come at them with some really hard stuff, think about saving it for at least near the end. They're not as focused. They're a little tired. Maybe they didn't have lunch, whatever it may be. One of the allegations Chase made is that Mr. De Niro had asked her to scratch his back on numerous occasions. And as I said in opening, this is part of the gender discrimination, that he wouldn't ask a man to scratch his back. And that there was one time where he asked her to scratch his back, and she said, "Why don't you use this back scratcher?" A gift a friend had given to him. And he looked at her and he said, "I like the way you do it." And that's exactly how I said in opening, and it was kind of creepy. Intentionally so. But this is Andrew getting into it near the end of his testimony, asking about scratching it back. He doesn't want to answer. And then he says, sort of surprisingly, he admits it. He did do this. Andrew says there's more than once. He says twice. So twice. Okay, you got me. I don't even know what you're talking about. I'm sorry. This is nonsense. And when she said you used a back scratcher, you said, "No, I like the way you do it." No, I would never say that to her. And if I did say it like that, you would say, "No, you could do it because of the back or whatever." It was never with any disrespect or lewdness or any kind of weirdness you're trying to apply. He turns and he looks at her and he goes, "Shame on you, Chase Robinson. God damn it. I'm sorry." He screamed at her and then cursed in the middle of the trial in front of the jury. Right? Right? I mean, I was sitting there, he's there, I'm here, Chase is right there. He is screaming at her in the packed house with the press. And this is a packed house to see De Niro testify. And he just lost it. Fabulous for us. That's a good, strong ending to cross-examinations. All right, direct examination. Clear, memorable, credible. That's what you would like the testimony to be. This isn't quite as fun as that last slide. Can I go back and just... It was remarkable. It really was. And hopefully invulnerability to cross. So I want to talk today just about preparation. Before I do, I think you probably can guess this answer, but how do you conduct an ineffective director cross?
Don't do it. Don't practice.
Okay. I would say my answer is read it. Right. Do not sit down there. Do not look, particularly younger attorneys who are watching this. Do not sit and look at your questions. You look at your question and then you ask the witness. And then you look at your question and you ask the witness. And before the witness is done, you're looking at your next question and you're not hearing the answer. You're not engaging with the witness. Hopefully, you know what you're going to ask generally. What I do is I will go through however long of questioning and then take a quick pause, look at my notes. Okay, I missed one, ask that, and move on. Do not stare at your notes while you're questioning the witness. Obviously, you need to be prepared on the facts, prepare the witness, and then prepare yourself to question the witness. So, well, I'm sorry, one more point. There's always going to be some objections. Some you can anticipate, some you cannot. Before every trial I have, there's always certain questions or certain exhibits where I want to make sure I'm getting that in. I will check the rules of evidence again and have a little note to myself if there is an objection, what the basis is to get it in, right? They're going to come, try and anticipate what they're going to be. All right, we got a lot of experienced attorneys here in this room. What would you say, show of hands, do you go through every question? Or do you just go over the topics? How many do every question with a witness you're prepping? That's the witness. Okay. It's me and David. All right. I go through every question. I give the caveat of I may not ask this exact question. I may not ask it in this exact order. We may talk more about one topic or another, particularly if it's a witness who has been sequestered, can't come in, doesn't know what's happened. Things may have changed dramatically. So I always give that caveat, but I personally like to go through the questions with the exhibits so that both I and the witness know what the answer will be. Because a lot of times, even after prepping, hours, days, whatever it may be, you ask a question, you think you know the answer, and you get something different. I would like to know that while I'm sitting in a conference room rather than in the middle of trial. So Chase, very, very bright woman, encyclopedic memory of her time at Canal. That was fantastic. It was also terrible in that she could go down sort of these rabbit holes of details and stories and how things linked up. I probably spent more time preparing her for her direct than any other witness I've had, by far. And it was trying to winnow down all the stuff that she knew. And again, this is a young lady who'd been out of work for 4 years because her boss, her former boss, had sued her and maligned her in the press. It was very, very hard for her to give any sort of concessions. Mr. De Niro was a very generous boss. He gave extremely nice Christmas gifts. He paid for some of her trips. And it wasn't just her, other employees. I think for her 30th birthday, he got her a Rolex watch. He paid in the months before she resigned. She went to Hawaii for 2 weeks. He paid for that trip as a Christmas gift. I wanted all of that to come out on direct, right? Because if I didn't, she was sure to get crossed on it, right? Like, how can you dare complain about this man, all he's done for you? It was hard for her to do that. And we had to work to do that. But I think it was very, very important to get it out first. But that was a challenge. And what I kept telling her is like, look, the defendant, they can't have it both ways. He can't give you, a Rolex for your birthday and pay for Christmas gifts and do all these wonderful things and then turn around and say, yeah, but I didn't give you the Sky Miles that didn't cost me anything. I didn't agree you could have your meals reimbursed, right? They can't have it both ways. So we had to get out the generosity in one form so I could say he was being generous with this other stuff that they're complaining about. We had hoped that we could get through Friday without Chase testifying. Huge stage. Again, she's in the public eye. There is a ton of press. Every morning we'd come in to the courthouse. Every night we'd leave. The paparazzi was there. The Sam Bankman-Fried trial was going on at the same time. So they had all their trucks there. They knew who Chase was and they knew De Niro. There was a lot of pressure on her. She very much wanted the weekend to go through everything one more time. Trials are fluid, moved more quickly. This is about 4:15 on Thursday afternoon. Ms. Chen has just finished and the court says to me, any reason why we can't do 20 minutes to plaintiff? No reason. I walked over to Chase and I said, you're up. And she got up and she did great. Now, one of our big first questions was going to be, can you tell the jury what it was like to work for Mr. De Niro? And she was going to say something like, it was a roller coaster, right? I couldn't win for losing. So I do this grand gesture. Can you tell them what it's like? Objection sustained. I asked it a different way. Objection sustained. And then I moved on. And I think the objection was, it was just too broad. There's only a couple years at issue. We ended up breaking it down and she went through all the details. But I can't tell you how much time we spent working on what that great answer was going to be. And I asked it, objection sustained. But a little later on, I got to ask her this. Did you hear his testimony that he never yelled at you? Yes. Is that accurate? And she goes, he yelled at me 2 days ago. To much laughter from the jury. All right. Getting into the details, we wanted to explain the discrimination and retaliation, our claims, but I was very focused on refuting the Sky Miles, the credit card charges, the loyalty. That's where I spent the most time with her. And it kept saying, why? What she had said, what she testified her deposition was, Mr. De Niro just said she could have the Sky Miles. We believed her, But it was, well, why? Well, it was a perk. Why? Well, because da, da, da. And we ended up going back about 10 years and figuring out why. Very quickly, and this was kind of the easy part in terms of she made a complaint. It's an email to Mr. De Niro, who everyone knows him, calls him Bob. She wanted to get out of the middle. She wanted to get out of the middle of this relationship with Mr. De Niro and Miss Chen. And that's exactly what she testified to. And he said he understood that. She sent a later email saying that she was worried about what had happened with Robin and Grace. Robin was a former assistant to Mr. De Niro. Grace was his ex-wife. And as Chase understood it, Grace, the ex-wife, complained about Robin to Mr. De Niro, and he fired Robin. So she was saying to herself, things aren't going well with Tiffany Chen. Bob is going to fire me. I don't want that to happen. I want to get out of the middle of this. And that's exactly what she testified to. So in some ways, that was sort of the easy explaining with the retaliation piece. These are the counterclaims: the conversion, breach fiduciary duty, breach duty of loyalty. They had claimed that she'd spent about $60,000 in a couple of years on Ubers and taxis, tens of thousands of dollars at these various restaurants. That she took a trip to LA, supposedly to just see a friend rather than for work, stayed at a nice hotel. She lied about her vacation days and the whole thing with the Sky Miles. So this is what I really wanted to focus on in her testimony. The authorization, acquiescence, ratification, and then no damages. Those are our arguments in closing. But we wanted to talk about the authorization, how he had authorized her, he, Mr. Niro, had authorized to do all these things. And this is a summary of the result of the why. 2008, when she first started working for him, he wanted her on call 24/7. So she was taking taxis all the time, because if she was in the subway, but no cell phone coverage at the time, and he called her, she didn't pick up, what would happen? It's kind of like you heard the voicemail. So at some point she said, listen, you want me to be on call 24/7, you got to pay for all my cabs, whether I'm 9 to 5, Monday to Friday, or at any time. He said, fine. A couple of years later, she ends up going out she moves to LA. She kind of wants to get some space. She goes to him and says, Bob, I'm spending about $2,000 a month on taxis. So what I'd like to do is give me $2,000 to put towards my rent in LA. And he said, okay. Now you may be saying to yourself, $2,000 a month on taxis, that's a lot. I asked her that. And she said, well, I was on the Upper East Side of Manhattan, airway down in Tribeca. Here's about how much it costs. Do the math. It was about $2,000 a month. So he agreed to this meal, agreed to rent when she went out to LA. He also agreed to a meal allowance. That was one of their complaints. She was charging too much for lunch and dinner when she wasn't really working, right? Like if she came down to the Canal office and ate at her desk, that was okay. But he had said at times she could work from home. So she'd be working at home, she'd get a lunch, and she'd charge that. That's what they were complaining about, but she testified and had some emails showing, in fact, that it happened. Then she comes back from New York in 2015, and she says, hey, that $2,000 you're giving me a month for rent, well, now I'd like that as a pay raise. I'm going to be living at home with her mother. I don't need that money, but I've earned it. Let's just up my salary by $24,000. And he said, not doing it, not giving you a raise. She said, okay, well then how about if you give me all the Sky Miles? Doesn't cost Canal anything. He said, okay, right? Then she was allowed to work from home, and then she got her final raise. And really kind of tying this all together is she took taxi allowance, turned it into rent, turned it into Sky Miles, and ultimately a basis for her final raise, but she was able to tie this story together such that it wasn't simply, he told me I could have them. We were able to piece it together for the jury. And I'm doing this very quickly. There was a lot of testimony, numerous emails over the years, but we were able to establish, yes, in fact, he had made all these agreements. And when you step back, like, all right, so she took the 5 million Sky Miles. He agreed to that years before. We also talked about this breach of the duty of loyalty. A couple of the highlights, there was a trip to the emergency room where he had fallen, Mr. De Niro had fallen, and he calls her at 4:30 in the morning to go with him to the ER. He is married at the time. He has adult children at the time. He doesn't call them. He calls Chase Robinson. And she goes and meets him the crack of dawn and goes with him to ER. And while they're there, who does he have put down as his emergency contact? Chase Robinson, right? This was a loyal employee, calling her at the grandmother funeral, taking care of all these things. The day after the day she resigned, she sends an email. She's finally had it. She says, I resign. He responds back and says he needs some information about his kids and the code, dealing with some things with his kids. She gets it for him and gives it to him, right? It was all about this loyalty. And then this was just a little nugget. You can't really see it, but she was accused of all these overcharges of various things. And I said, well, did you ever charge things that were personal on the company credit card? And she said, there were a couple of times. She had, I don't know, it was platinum or gold Amex. And she said, there were times I accidentally used the company card and it was for personal. But she said, I would write a check. I wrote a check for it. So this is a check for all of, what is it, $519. She submits it to the accounting firm with a note. Michael, enclosed is the charge on the Amex that I canceled in my reimbursement. Bob and I have Amex cards that look exactly alike. Sorry for the delay. Best, Chase. Now, ladies and gentlemen of the jury, does that sound like someone who's trying to steal from her boss? This is instruction on her damages. And under the law, we were not able to, under the retaliation, we were not able to ask for front pay. She had resigned. But what I was trying to, and our claim for constructive discharge had been court had granted summary judgment against us on that. So truly the retaliation was just that Ms. Chen retaliated against Chase for raising these issues in those 2 emails you saw. And Chase decides I've had enough and she resigns. But this is our hook. And that is, she could be compensated for emotional distress or reputational harm. And so what I went through with her was the harm to her reputation. She had been out for 4 years. She testified she had applied to 635 jobs and had not gotten a single interview. Again, before this trial, if you'd put Chase Robinson's name into Google, all you would come up were these horrible stories about her being a terrible employee and Netflix and overcharging, etc. Right? She was trying her darndest to get a job. But this was the hook for the reputational harm. This is my last question to her on direct. That's one that hung. She answered that. She was in tears, let it hang, then gathered up my stuff and then walked out. And I went through, this was the final slide at the end of my closing, talking about damages and just going through in all ways that she'd been damaged by what the defendants had done. So moving past just direct, do you redirect? Anytime you've got a witness you've put on direct, you'll have the opportunity to redirect. And the question is, do you redirect? A quick war story as an AUSA in my first trial, Luis Mondragon Bibiano was our key cooperator. He testified, did a very good job. Peter Stryans was the defense attorney. Mr. Stryans crossed him. I got up and redirected. Peter recrossed. I redirected. Peter recrossed. I finally sat down next to Hal McDonough, who was a terrific trial attorney, very experienced AUSA. As the next witness was coming in, Hal leans over and goes, I usually don't redirect my cooperators. I said, okay. You didn't tell me I'd done anything wrong. He said, I usually don't redirect my cooperators. And the reason why is because someone like Mr. Raven here, every time I get up and redirect, that 1 or 2 questions that he really meant to ask on cross that he's forgotten when he sat down, he'll get up and I'll get to ask him. So you got to ask yourself, do you even want to redirect? Sometimes you don't. Chase, we felt we had to. She got crossed for, it was a couple hours on Friday, the entire day on Monday, and then like another hour on Tuesday morning. It was about 8 of their 18.5 hours they spent crossing Chase. So I got up and I told her, literally looking at the watch, I'm like, we have an hour. We're going to get through like 12 topics. We were going to move. And we did. It went terrific. It was because we'd spent so much time together. We developed this rapport. And I was like, here's what we're talking about. We had 5 minutes outside the courtroom. So I was like, here's what we're talking about. She's like, well, I want to talk about this. I want to talk about that. I'm like, we don't have time, Chase. We got to talk about this and get it done. And we did. I thought it went well. All right, turning to closings. I think there are people, I've heard people talk about, well, you should write your closing first. Think about what you want to say in closing. I always want to think about writing my opening first because I know the opening I can control. I know what I'm going to say. The closing, I don't know why this is going in and out. The closing, a lot of times you don't know what's going to happen during the trial. Trials are fluid. You may think your star witness is going to be the star. They're terrible. Your worst witness may be the star. That key piece of evidence that you thought you're getting in does not come in. Robert De Niro yells at Chase Robinson. I could not have predicted that. But you should be thinking about what you want to say in closing during voir dire, during your opening, during direct, during your crosses. I always get a transcript of opposing counsel's opening. First day, go get a transcript, get a rough version at least, and that way you can have it for later on in the trial. Certainly at closing, say Mr. Raven got up and told you were going to hear A, B, and C. Ladies and gentlemen, you didn't hear any of that. So that's a practice of mine. I keep a closing notebook. So what I mean is I will have a manila folder that I keep separate apart from everything else. And as the trial happens, I will jot down notes that I want to use for closing. And really what I'm going for is like something memorable. Obviously the yelling at Chase, some moment, the reaction of the jury during particular testimony, some exhibit, that really seemed to hit the mark, whatever it may be. But then when it comes time to write your closing, you're not starting from scratch. I've got 2, 3, 5 pages worth of notes to work off of in addition to everything I've been watching in the trial. Obviously, primary job, get in the evidence you need to get in. Second is to get in any additional evidence where you want to tell the story. As a prosecutor, you got to get in the evidence to prove the elements, whatever flavor or color you can add to it, all the better. So this is, again, these are all my practices. You work off the evidence, the inferences, you're looking at your jury instructions, you look at your notes that you've been keeping, that I've been keeping. Josh, it keeps sort of going in and out. I don't know if we can fix it. So I like to write it out by hand. I find, and I don't know about everyone else, but when I type something, I try to type an opening or a closing. If I'm typing it out, if it's not perfect, I can easily delete it and then start again. And I will spend way, way too much time trying to write the perfect sentence or paragraph. If I just have pad and paper, once it's written, it's already out there. And the thoughts for me just flow much more freely. So in this case, there were very, very long days, and I got to Saturday night and I hadn't started my closing yet. And I'd gone to dinner and I got back to the hotel and I had a pen and paper and I sat down and just wrote for about 4 hours. Just throwing up onto the page everything I could think of. I had my closing notes there with me and I just wrote it all down. And I put the pad down, the pen down. I was going to go to bed and I said, we're going to win. We're going to win. We've got the better case. We've put on a better case. They're going to give her some money and they're not going to find in the defendant's favor. Like I actually had a conversation with someone in this room the next day and I said, I wrote my closing last night. We're going to win. So in terms of the contents of a closing, I like the I told you so. Talk about what the jury still needs to resolve. It's not everything that's come up in the trial. Some things may be so clear you want to focus on particular issues. Thanking the jury very briefly, and then directing them to the verdict form. So that's something I do, I got in the habit of doing as a prosecutor, where I would literally hold up the verdict form with boxes checked and say, ladies and gentlemen, you go back to the jury form, this is what it should look like. Guilty, guilty, guilty. If there were certain drug amounts, what amounts? I had a bad experience in my first trial where I think the jury got confused on some issues. So I like to hold up the verdict form and literally walk them through it. Let's go. Okay. All right. Yeah, I told you so. That's easy. I've already talked about that. I want to talk about the seed I planted in opening. Do you remember what seed I planted? It was about the memory, comparing De Niro's memory to Chase's memory. I think there are shepherds on the jury. There are leaders. Any group, you're going to have some people who are leaders. Think about giving the shepherds what they need to be able to convince the other people who are on the jury. If you can say, ladies and gentlemen, go back and focus on X. When you're talking about this topic, I'd like you to talk about X. There will be note takers. They will write it down. And the note takers are another reason I always have the exhibit numbers listed in my slides if I'm using slides. The obvious question, what I like to do is ask a question where I think the jury will be able to answer it easily. In this case, it was a case I tried with Cat Booth, a defendant named Carl Hampton. He defrauded a couple of elderly ladies, a couple of victims. And there'd been a story during the trial. One of the victims, her attorney, was asked about what she was like, whether she was frugal. And he kind of chuckled. And he said, well, there was this thing with Omaha steaks. And he said how Barbara Wade had told him that she had ordered Omaha steaks, like a mail order steaks. And when she got them, she opened up the packages and she weighed each of the steaks on her scale in her kitchen. And a couple of them weren't quite what they were supposed to be. So this 80-year-old lady called up Omaha Steaks and said, y'all cheated me. I want my money back. And the jury kind of chuckled along with them. So the defense in that case was essentially that the defendant testified that Miss Wade, this elderly woman who had dementia, had given him all of this money of hers, millions of dollars, and that she wanted him to spend it however he wanted. And the evidence came out that he had spent thousands of dollars, like $1,000 a day on lottery tickets. And so I wanted to talk about would Barbara Wade have been okay with that. So I said to the jury, I said, do you all remember the story about the Omaha Steaks? Nods, lots of nods. And then I went into the story, right? That was something in my closing notebook. It was a memorable point during the story. I said, do you all remember this? And it had them all trigger back to that testimony. Thanking the jurors. I think some people want to go on and thank them and think it's somehow, engendering them to the jury, getting them to like them more. I just say the shaking of the head back there. I'm with you. I just say, ladies and gentlemen, on behalf of myself, the trial team, Ms. Robinson, thank you very much for your time and your attention and your patience in this case. It is one sentence. And I don't do it at the end. I do it before I go to what will hopefully be my strong, ending strong with the closing. I already talked about this, whether you used a verdict form or not. Things not to do in closing: go through every witness's testimony, attack opposing counsel. Absolutely not. Absolutely not. You're there to talk about the evidence. Do not mistake the law or the evidence. You're going to get an objection. You may get chastised by the judge. And if you got a weakness, acknowledge it and explain it. So this is the start of the defendant's closing. We went back to the movie analogy. And again, I didn't think that this was particularly strong. I understand he had, an idea of how to do it. And again, he was a very, very good trial attorney, but he wanted to go with the movie theme. And then he went in and he said something that was very surprising. So if you're on the clock, you only have a certain amount of time, or even if you're not on the clock and you've got your prepared remarks, if you get to go second or you're going to do rebuttal, be ready to adjust. You never know what the other side is going to say. So counsel got up and he said, having someone use the B word in frustration a handful of the times over the years, it's not a big deal, especially when the evidence shows that you engage the same kind of language yourself. I was stunned at that, because there's an instruction that the judge is about to give that said a single comment can be enough. And he essentially said, boss calls you a B, it's a big deal. We had 8 jurors. Was it 6 of them were women? 5 of them were women. So I knew I wanted to talk about that. And the bathroom break and the wink is this. Defense gave 50 minutes of their closing. Judge had a brief sidebar where we made an objection to something that had been said. And as we're all walking back to counsel table, about ready to start, one of the attorneys, Mr. Niro, says, Your Honor, Mr. Niro had to use the restroom. He's left. He got up and he left the courtroom. So the judge says, well, I guess we'll just wait. And by the way, he'd been there for opening statements, his testimony, then came back for closings. That was the only time he was there. But so we waited. And what was great is I had a couple of minutes to kind of gather myself. I was incredibly tired. I'd had like a package of M&Ms and a Coke for lunch. It was just all adrenaline. Like that was literally my lunch. But it allowed me to kind of like gather myself. Mr. Niro comes back in. We all stand up. And the jury's going to be coming. The jury's here. I'm standing at counsel table. The jury box. The jury will walk out. I was lucky enough. My dad had been unable to resist watching his son in a trial. And so he'd flown in the night before. So he's standing about there in the front row. And the jury's coming in. And he looks at me and I look at him. He gave me a wink and I gave him a wink. And it was just like this support, right, that you can only get And it just like, it meant so much. And it just, again, like steeled me to turn and give this. If not for that, it wasn't so much the wink, but the bathroom break. Let me do this. I said, ladies and gentlemen, this is a civil rights trial. The defendant's counsel just got up and said during his closing, your boss calling you a bitch is not a big deal. And I looked at every woman on the jury. I said, this is why we have civil rights laws in this country. And to quote Mr. De Niro when he yelled at Chase, I turned and looked at Mr. De Niro. I said, shame on you. This was the seed. Talking about they get to compare the memory and recollection. So the jury, I told you about that. And then I put up this slide. This is kind of funky when I was copying the slides, but we had counted, there were about 140 some times Mr. De Niro in his trial testimony had said, I don't know, I can't recall, that may have happened. And so I said to the jury, so ladies and gentlemen, I ran out of space on this page to have all of it and got another chuckle. But the point was, is that Chase had testimony, who, what, where, when, why, and oftentimes documents. Mr. De Niro had said, I don't know, I can't recall. And his great line of, it might have happened, that could have happened. That was huge, I think, for us. So I thought, and to be very clear, I never thought Mr. De Niro was lying. He just didn't recall a lot of these things. You know, Chase wanted a, taxi fare. Okay, no problem. Now you want to rent for when you move out to LA? No problem. On the Sky Miles? Sure, no problem. Right? Meant nothing to him. Right? He's worth $500 million. Chase Robinson, it meant a lot. But to make that point and to have that up there, I thought was effective. So you want to finish strong. And again, I think a lot of people you will see as they're finishing up their closing, say, ladies and gentlemen, we'd like you to find in our favor on all counts. Thank you. Do not do that. State it, let it sink in, and then walk away. This is how I ended it. And I got in a little bit of trouble where I said, I'm asking you for justice on behalf of all civil rights litigants like herself. Whoops. I'll come back to that. Rebuttal. If you're going to do a rebuttal, make it short and sweet. If you want to use an analogy in your closing, it better be tight. And I would only use it in rebuttal. If you give an analogy in your initial closing, opposing counsel will use it against you somehow. Save the analogy for rebuttal because there's nothing they can do about it once you give it. This is how the defense counsel ended his rebuttal. He had 10 minutes. I've got 5 minutes left, but I'm going to sit down. And I thought to myself, yeah, a trial lawyer who has 5 minutes left and they're going to sit down. I guess, my closing must have been pretty good. But that's how he ended it. Is that a strong finish? Again, I don't think so. Be professional throughout. Don't lose your credibility. Don't try to lunge across the goal line in your closing. That's when you fumble it. All right. So the benefits of building credibility. I got in trouble 3 times. First was, there'd been a lot of talk about Chase had this idea. She wanted to testify about how Mr. De Niro's wife, Grace, years before all this, had mistreated her. And that's different from the point of her thinking that he fired the woman, Robin, because Grace didn't like Robin. she felt Grace had mistreated her. The judge made it very, very clear. We're not talking about that. It's not relevant. It was way long ago. Don't want to hear the word Grace. So I was examining Chase, and I had asked her a question which would not call for the answer to include the word Grace. And my colleague had handed me a note. And as he was handing me a note and I was squinting to try to read his handwriting, I heard from the witness stand the word Grace. And as soon as he did, objection sustained. And Judge Lyman said, "Counsel, you know better." I'm sorry? "Counsel, you know better." In front of the jury. I was like, what just happened? So when we took a break, I asked my colleague, I said, did anything that I asked, would it justify her starting to talk about Grace? And he said, no, it had nothing to do with that. I said, good. So rather than putting it up, I will just read what I said to the judge. We had the break. I said, Your Honor, I just wanted to say you'd made a comment that I know better. Your Honor, I did not hear what she was saying. I was looking at a note. I was trying to do something else. I know I have not appeared before Your Honor. Excuse me. I know I have not appeared before Your Honor before, but that is not how I practice, and my deepest apologies to the court for what happened. I did not even hear what she said. And the judge looks at me and says, I appreciate that very much. Thank you, and I accept that completely. You and your team have behaved very professionally. I said, thank you, Your Honor. I mean, that could have gone so much worse, but I think he appreciated I had been professional, our team had been professional, and he accepted the apology. The next one was there was a point where Chase had been having a hard time giving straight answers, not straight answers, but she wouldn't just directly answer a question. He had to chastise her a number of times. And he had said something to her once or twice while she was on the stand. And during a break, she said to him, Your Honor, I'm having a hard time hearing you. It was literally because of the brain surgery she had when she was 10 or 11. She said, I can't hear out of this ear. And the judge sat like this. So that was in front of the jury. Came back, and there was a point where she was getting asked a question. And the judge said, can you hear me? Or do you hear me? Answer the question. It didn't seem like that big of a deal to me. So my colleagues felt that was a very big deal. And there was a discussion about what we should do about it, perhaps sending a letter to the court that evening, how to address it. And as sort of a backstop to all this, going into the trial, we did not think we had a good chance. So the idea was that we were going to appeal and possibly, depending upon how the trial went, whether we would seek to have a different judge. I said I was not sending a letter, and I addressed it with the court. But I won't read this. It's a little long, but essentially I brought it up and said the word respectfully about 5 different times when I raised the court that respectfully, when the court said this, the jury hadn't heard what she told you earlier. Respectfully, Your Honor, we think this may have caused some prejudice, and respectfully, Your Honor, we ask that you give an instruction to the jury that you weren't chastising her about that. And he said, well, I think I've been tough on all the witnesses, so I'm not going to give an instruction. But I made my point, and he didn't get mad, which I was glad about. And then this was in closing. We had alleged punitive damages. We were not allowed to ask for them. Ultimately, the judge said he would not include the instruction. And in talking about closing with some colleagues, language had been suggested, sending a message, that sort of thing. This was the first employment case I'd ever worked on. And it didn't dawn on me, break one of my own rules, right? Be prepared, know the law. It didn't dawn on me that I couldn't say something like that in a case where there's no punitive damages. So I said this. And afterwards, after closing, defense counsel objected because I'd explained single white female. And then the court said, and to me, this was chilling. He said, I'll hear from plaintiff on that as well. I had an issue with respect to plaintiff's summation the defendants didn't mention. I was like, uh-oh. But it was to the portion of the summation that had the theme of send a message. This is a high publicity case. The public is watching, send a message, which I think is plainly improper argument that appeals to the passions of the jury and tells them to disregard the facts of this case or to not judge the facts of the case based upon the evidence, but to take into account the fact that whatever they decide in this case will be taken as a message to others. So I'd like to hear about that as well. I was, like I said, it was chilling to me. Went through some other arguments. The judge said, okay, Mr. Hannafan, do you want to make me comfortable with respect to the bit about the media? I said, Your Honor, I'm not trying to quibble with Your Honor. I don't think I said media. I think I said this is public. He said, yes, you said this is public. I said, which it is, and that the verdict would have meaning, that it will have meaning with respect to holding the defense accountable. And then there was a bit more back and forth. And I talked about how Mr. Schoenstein had said, so your boss calls you a bitch, no big deal, asking them to completely disregard the law. The court said, I thought you were very effective in your response to that. You handled this comment. I was like, oh, good. I said, I appreciate that, Your Honor. The judge finally says, all right, no one's asking me to do anything with respect to it. And I accept the way that you put it. You tried to handle it very deliberately. I said, I appreciate that, Your Honor. But again, like that could have gone very poorly for me, but I think the judge understood it was a mistake. I had been respectful. He ended up not, I offered curative instruction. He did not take me up on it. Speaking of instructions, I think we're getting right at time. New York, the Second Circuit does not have pattern instructions, unlike the Sixth Circuit here. If you have pattern instructions, use them. If not, write the first draft. The deliberations, very quickly, we come in that morning for the jury to deliberate, and the judge comes out and says, I just want to let everyone know that juror number 7 is not going to be here today. She's in an ambulance on her way to the hospital. Does anyone have an objection? Juror number 7 was like our finest juror. She was a slightly older woman, very well educated, a lot of nods, seemed unhappy with Mr. De Niro. Well, what do you say? I said, Your Honor, no objection. One of my trial partners like, oh, come on. But again, the trial's not over. There may be more things happening. I'm not going to upset the judge. So she was out in Southern District of New York. The jury does not get the evidence in the jury room. They have to request it. They make a request for specific exhibits or to hear a call, which they did. And then and only then do they get it, which I'd never heard of. So we get to know the jury has a verdict. And as they're walking in, I turned to my trial partner, Andrew, and I said, our lives are about to change. It may sound arrogant, but I was convinced we were going to win. And I was right. The court got the verdict form, took it out of the envelope, looked at it, flipped it over, put it back in the envelope. Opened up the envelope, looked at again, put it back in the envelope. I'm not sure he could believe it. And then the courtroom deputy, the way they do it is they just say, there's a question 1, do you find Robert De Niro liable? Yes or no? And the foreperson has a mic and says yes or no. So De Niro not liable, Canal liable on discrimination and retaliation. They awarded Ms. Robinson $632,142.86 on each claim. Found in our favor on all the counterclaims. Nothing for the defense. Press coverage lessons. Tons of press there. Again, the paparazzi in the morning coming in and at night. When we got the verdict, I think it was a little bit of a surprise in terms of us having a press response. If you're in a case like this, have a response ready to go, because as soon as the verdict comes out, the press will want to speak to you, maybe out on the courthouse steps. You don't want to be taking time to craft it. Defense counsel went out immediately and said, this is a victory for Mr. De Niro. No finding against him. Well, $1.2 million. They asked for 12. We consider this a victory. That was the first quote that the press got. And then I had to go back out a couple minutes later and try to refute that and say, of course, it's not a victory. Ms. Robinson is totally vindicated. So number 4, make sure you see your Uber before you walk out of the courthouse. So this was the scene as we came out after the verdict. That's Chase and Allie Harwin, a woman who'd been in the front row, who is an amazing attorney and a huge help. And she and Chase had bonded. This is normally dark. The light on this is from all of the cameras going off and all the video. So we got interviewed. We didn't want to have Chase make a statement. She very much wanted to. We thought it was best if she didn't, and our firm released a statement. I had called an Uber and then couldn't find it when it showed up. So I included this picture. This is me trying to find where the Uber is. And it was about 20 yards that way. And where I'm standing there going, is there a Toyota Highlander? Does anyone see the Highlander? Because they just kept badgering her with questions. And how do you feel? And what do you want to say with them? And all the photos. So get the Uber before it gets out. All right. Very quick. I mean, I'll just wrap up. Expect the unexpected. All these things that happened. These are questions I've gotten. How long was I in New York? I was in New York for a month, living in a hotel, which was tough. I missed my wife, missed my boys. I never talked to Mr. Niro. He's just like he is in the movies. He really is. Like the call you heard, that could have been from one of his movies. I do still watch his movies. We did not get to play the call. Why did they find Mr. De Niro responsible? I think they felt it was really Tiffany Chen who was the bad guy, so to speak. And I think they thought he was honest when he testified. And his position essentially was, I treated her very, very well for a long time. Yes, I may have, he didn't come out and say, yes, I said some bad things and I shouldn't have. But he was like, you know, I treated her well. I paid her a lot of money. She complains about these things. That was part of her job. And I think they credited his testimony. And the damages amount, if you multiply that by 7, so we had 8 jurors, juror number 7 didn't participate. You multiply that amount by 7, it's a very round number. And I think what happened is the jurors all decided they were going to award Ms. Robinson some money. And they went around and said, well, how much would you give her? How much would you give her? How much would you give her? And they added it up and they divided it by 7. That's what I think happened. All right, finally, I can't be David Rabin or Miller Bouchon or anyone else in this room in terms of a trial lawyer. You have to be yourself, particularly if you're a young attorney. Try to emulate the good things that experienced trial lawyers do. Do not try and imitate them. You got to be yourself. Let's be authentic. There are ways to try and get practice. Raise your hand, be on a second chair, participate in trial prep, do whatever you can, even if you're not getting a trial yourself. Trials are a grind. Everybody wants to win. It's really the taking the time to be prepared that matters. That's it. I'm done. Thank you very much. Oh, thank you, National Bar. Thank you, Cameron. Thank you, Josh. I'm happy to answer any questions if anybody wants to stick around, and I apologize for being a little over time.
Thank you, Brent.
All right, thank you.
Anyone in the room who is not currently an NBA member, who would encourage you to join, so you can have access to this and more fantastic CLEs. I really appreciate you all coming. Please tell all your friends to be available on our website, and thanks for coming.